All right, there you go.
Good. Okay, let's try again. Good morning. Welcome to the January 14, 2026 meeting of the New York State Western Regional Board of Review. My name is James Burton and I serve as chairman of this board. To my far left is Mr. John Limbeck. To my immediate left is Mr. Rick Papich. To my immediate right is Craig Jensen. And joining us remotely is our fire official, Mark Kavanaugh. Good morning, Mark. So before we get started with the matter before us today, we have a little bit of housekeeping to do. It's that first meeting of the year where the board has to select a chair for the coming year. So I need somebody to nominate one person who sits on this board to serve as chair for the 2026 calendar year.
This is John Limbeck. I would nominate Mr. James Burton to continue as chairman of this board.
Any other nominations?
No, I'll second the nomination if necessary.
Okay, so we need to put this to a vote. Mr. Limbeck? Mr. Papich?
Aye.
Mr. Jensen?
Aye.
Mr. Kavanaugh?
Aye.
I will abstain, so the record should reflect that the board has elected myself to continue to serve as chair of the board by a vote of 4-0. Now, some other housekeeping. For those of you that plan to testify today, when you come up to the podium or take a seat at the table, please make sure to include your name and legal address for the court reporter. And when you're making statements, please make sure that you're making the statements directly to the board and not anybody else in the courtroom this morning. The first case before us, the only case before us today, is in the matter of petition number 2025-0919. Petitioner is David Ryan. This petition pertains to an appeal for an existing building seeking compliance with Chapter 13 of the 2020 Existing Building Code of New York State for an alteration and change of occupancy from a Group U occupancy to a mixed-use Group A2, F2, and S2 occupancy. The existing building is of type 5, wood frame unprotected construction, 3 stories in height, and contains approximately 6,462 square feet in gross floor area. The building is known as Harry's Barn and is located at 1724 Holman City Road in the town of Paris, County of Oneida, State of New York. Petitioner is seeking an appeal of a local code official's determination regarding the applicability of the following code sections. First, 19 NYCRR Part 1227, Existing Building Code of New York State 2020 edition, Section 101.3, which states that the intent of this code is to provide flexibility to permit the use of alternative approaches to achieve compliance with minimum requirements to safeguard the public health, safety, and welfare insofar as they are affected by the repair, alteration, change of occupancy, addition, and relocation of existing buildings. Petitioner contends that petitioner's Chapter 13 Performance Compliance Review Analysis, dated February 4th, 2025, and submitted as an alternative method for code compliance of existing buildings, is in full compliance with all mandatory provisions of the Uniform Code, the Energy Code, and applicable reference standards, and is therefore requesting that the Board of Review overturn the denial issued by the code enforcement official. And 19 NYCRR Part 1227, 2020 edition, Existing Building Code of New York State, Section 102.2, which states that this code is part of the New York State Uniform Fire Prevention Building Code, promulgated pursuant to Article 18 of the New York State Executive Law. The provisions of this code shall not be deemed to nullify any federal, state, or local ordinance, administrative code, rule, or regulation relating to any matter as to which the Uniform Code does not provide. However, subsection 1, pursuant to 383 1 of the executive law and except as otherwise provided in paragraphs A, B, and C of section 383, parentheses 1 of the executive law, the provisions of the Uniform Code supersede any other provision of a general, special, or local law, ordinance, administrative code, rule, or regulation inconsistent with or in conflict with the Uniform Code. Subsection 2, pursuant to section 379, parentheses 3 of the executive law, no city, town, village, county, or other municipality shall have the power to supersede, void, repeal, or make less restrictive any provision of the Uniform Code. And subsection 3, the ability of any city, town, or village, or the county of Nassau to enact or adopt and to enforce a local law or ordinance imposing higher or more restrictive standards for construction within the jurisdiction of such city, town, village, or county that are applicable generally to such city, town, village, or county in the Uniform Code is subject to the provisions and requirements of section 379 of the executive law. Nothing in this section 102.2 shall be construed as 1, affecting the authority of the state labor department to enforce a safety or health standard issued under provisions 27 and 27A of the labor law. 2, relieving a person from complying with a stricter standard issued pursuant to the Occupational Safety and Health Act of 1970 as amended. Or 3, superseding, limiting, impairing, or otherwise affecting any provision of the Uniform Code as now in effect and as hereafter amended from time to time. The petitioner contends that the New York State Agriculture and Markets Law 305A, which includes agricultural exemptions, should take precedence over the administration and enforcement of the Uniform Code with respect to the granting of approvals and permits in conjunction with the applicant's application for construction permits associated with the work previously performed and proposed to be performed as illustrated in construction documents and accompanying the permit application. Petitioner is requesting that the Board of Review compel the code enforcement official to grant the requested approvals in consideration of the Agriculture and Markets Law 305A. And 19 NYC RR Part 1227, 2020 edition, Existing Building Code of New York State, Section 106.2, which states that construction documents shall be in accordance with Section 106.2.1 through 106.2.9. The petitioner is appealing the determination of the code enforcement official that the submitted drawings and analysis do not fully document existing conditions or demonstrate compliance with all applicable code requirements for the proposed change of occupancy and is requesting that the board overturn the code enforcement official's determination. And 19 NYCRR Part 1227, 2020 edition, Existing Building Code of New York State, Section 1301.3, which states that for repairs, alterations, additions, and changes of occupancy to existing buildings that are evaluated in accordance with this section, compliance with this section shall be accepted by the building official. Petitioner contends that the code enforcement official has an obligation to accept a Chapter 13 performance review and issue building permits and certificates of occupancy and or compliance based on the results of the Chapter 13 performance compliance review performed by petitioner's consultant without conducting an independent review. Petitioner is requesting that the Board of Review overturn the denial issued by the code enforcement official. You may proceed.
you want me to stay on the podium to introduce us?
As long as you pull that mic close to you so that the court reporter can hear it and the people that are remotely connected, you can sit right there if you choose. Just please introduce yourself and your address for the record.
My name is Cynthia Collins.
Excuse me, Cynthia, can you please just hit the button to make sure the light turns green? Thank you.
Got it. Okay. My name is Cynthia Collins. Good morning to the board members. Thank you so much for giving us this time. My address is 1724 Holman City Road in Paris, New York, where the farm is. My sister Barbara Griffin is next to me, and her husband Rich Griffin is next to Barbara. We purchased this ancestral farm in December of 2006. The farm sits in an AR zone in the town of Paris in Ag District Number 6, and agricultural uses are permitted as of right. We are not subject to any aspect of the zoning ordinance. On June 16, 2021, we were granted AML 305A protections because we grow more than 51% of our ingredients for beer and cider. We hold a New York State farm brewery license since May of 2022, which allows us to serve our beer and cider by the glass in a tap room. Therefore, the barn is a critical part of our agricultural enterprise, both for production and marketing of our crops. In our pursuit of a change of occupancy for an A2 assembly to accommodate the tap room in Harry's barn, we've hired New York State design professionals, attorneys, licensed contractors to guide us in this process, and we follow their advice. The farm, the crops, and the brewery setup and finishes of the brewery have been investigated, inspected, and approved by the New York State Liquor Authority, the Department of Ag and Markets, and the Tobacco and Trade Bureau, which is commonly known as the TTB. We received brewer's notices from the Tobacco and Trade Bureau because we have finished the division between the cidery and the brewery with a 4-foot wall. We believe that we have done everything the code requires for the change of occupancy. We paid for the permit. And with the only outstanding issue that we see is upgrading the fire alarm system, which was requested by permit and denied. We need our certificate of compliance in order to open the tap room fully. We've been shut down since August of 2023. The entire farm operation has been shut down because we harvest hops and barley and harvest apples. We process them in the brewery area, and that's how we market our crops. Then it's put into the fermenters, but we have been disallowed from even technically entering our barn. We just feel the town is overreached with regard to the code enforcement because we are a farm operation. And Mr. Burden, you went over the 305A protections, and it's not like they're not applicable, because they are. It's because even the existing building code and the uniform code talk about public health and safety. So does the 305A. 305A protections are granted and allow us to operate our farm operation, including the tap room, which is our glorified farm market, kind of is where we serve our crops as beer and cider. But that 305A, I think, is subsection 1, also states that unless, and all the case law and determinations from the Ag and Markets litigations and decisions, basically, provided that we meet the basic code compliance, that unless there's compelling evidence of a risk to the public health and safety by opening our tap room, the town cannot regulate and restrict our farm operation. And I think that's where a disconnect has been all along, is that we're a farm operation first and foremost. The tap room is not a bar, nor are we a restaurant. We have some obligations under the farm brewery license to serve some food, finger food, so that people can walk around and try our beer, try our cider, and also eat something as they walk around. And the barn is set up for that. The tap room is set up for that. And basically the public access is to the tap room. It's not that large of an area. I think it holds 43 people max. I think our occupancy was established at 50, which is even a little tight. We would probably keep it because the barn itself has posts and beams, and we're very cognizant of keeping paths open for accessibility for people in wheelchairs. So we're just asking the board to take a look at what we've done so far, that we feel that we have met the minimal basic code compliance that is required in order to produce a very safe A2 assembly area for the people. I think like I said, I think the only outstanding thing that we need to do to bring the Chapter 13 into full force and effect is upgrade the fire alarm system. I believe I submitted the application for permit to do that with shop drawings back in October of 2023, and it was denied. And so we haven't been able to install that upgrade yet. So obviously we would like to do that. We need to do that in order to, again, bring full force and effect to the Chapter 13 review. And thank you so much for your time. It's been a while to get here, so we really appreciate being here. Thank you.
Thank you.
My name? Cynthia Collins, Barbara Griffin, Rich Griffin. Right.
Griffin.
Okay. Thank you.
Hello, I'm David Ryan, 18 Union Street, Sherwood, New York, 13460. I'm the petitioner in this appeal variance. With regards to the documentation that we submitted, there's the original October 2023 permit application, along with the associated design plans, which are provided by Albert Zigarelli, who is the record design professional on that permit application. Again, Albert Zigarelli provided a performance review in June of 2025, along with a set of associated plans for that performance review that went along with it. In both cases, we have provided the local code enforcement officials' responses to the plan sets, along with the performance review, and per our request to have an appeal variance board appearance to overturn the local code officials' non-issuance of building permit application, to issue a building permit application for the installation of a enhanced fire detections or fire alarm system, which time, once it's deemed complete and has been inspected by a third party, then a issuance of a certificate of compliancy for the project. Thereby, allowing the operation to fully be put into service for the clients and property owners.
I would just like to add that we started this project a long time ago, but in, again, October of 2023, we submitted a permit application for the change of occupancy with all the updates that we had accomplished, and also for the installation of our commercial septic system that we need for the brewery. The Oneida County Health Department approved the design, and the town, though, requires a permit to start installation and complete installation, which is fine. So we did the permit, we applied for the permit, we applied for the change of occupancy permit, and the checks were cashed. We're still waiting for the permit. And we, of all people, understand that the permits, once they issue, doesn't mean we get the certificate of compliance, but it means we can conduct what work we need in order to satisfy the requirements of not only the liquor authority, but also the health department. The health department itself has some oversight over us because we're not making food, but we're serving food. We do countertop appliances. It's all electric, like nachos, your finger foods, paninis that you just press into it. So the Oneida County Health Department has approved our cafe. They approved our water. We had to sink a new well. We've sunk a new well. The water was approved, but the water filtration system cannot be approved until we have and everybody uses the term CO in Paris, but it's not technically a CO. It's a certificate of compliance because it's an existing building, as I understand it. So until we get this certificate of compliance, really, it's the linchpin for us to move forward, because once we get that, we still have other things to do. We have to get the health department in to approve the water filtration system. We have to have the cafe approved. We have to, a bunch of stuff. So it's not as if they issue a certificate of compliance and, we're open the next day. There's a lot of planning, a lot of work. I can't tell you how much time and energy and money we've spent in just even the hops trellis. I don't know if you guys, the board has any idea of what goes into a hops and barley farm. But it's a lot of investment and a lot of capital in order to bring the trellis up. And we planted 500. When we first started this project, we retained an advisory company called Hops and Vines. So they helped us develop the amount of hops and barley. We have to meet the 51% requirement. When we bought the farm, it was our great-grandfather's farm. It had about 25 acres of productive apple trees, 4 different species of apples. So we began long before this project to clear out and start to harvest the apples. And now we have to do a little bit more work. We have to continue to prune them. We have to do good agricultural management. And so there's a lot of stuff going on, but we have been stopped dead in our tracks from doing this. Now, and the other thing I just wanted to let the board know is that we first started asking about using the barn for weddings in 16, 17, 18, because they were big back then. I don't know if they're so big anymore, but we applied for a zoning permit to do that. Our zone doesn't allow wedding venues and things like that. So we went through the planning board. They said, no, we already have a barn venue in town. It's like, oh, okay. So a work product meeting happened in maybe late August, September of 2019. And the town supervisor himself said, why don't you try a farm brewery? We'd get behind you for that. And they're, well, never thought about that, but we'll take it under advisement and think about it. And then the pandemic hit, so we had plenty of time. When we came out of the funk of the pandemic, we had a pretty good plan. And our attorney then, Charles Gottlieb from White House and Osterman and Hannah in Albany, he sent a pretty nice package to the town board saying, look at this, they're going to take you up on the proposal. We think it's a good idea. We're going to do it. Here's how we're going to manage it. Here's how we're going to meet our ingredient requirement. Here's how we're going to do this. This is our time frame, and so we submitted it. The town board went to executive session in May of 2020, and they came out, let our attorney know, that's fine. We're with you. And all of a sudden, when we actually started investing the money, all of a sudden they were not with us anymore. Because a lot of the issues that we've had with the code enforcement is subject to discretion, and we were given none. We never asked for special favors, never. We tried to comply, it's been brutal. But we think we've got the barn in a very, very safe and structurally sound position now. And we kind of, the inspection of the barn by Ms. Lamont, who's here, took place back in September of 2024. And that was important because we've been asking for it for a while. And it was important because the code official has I say it's a duty and obligation to walk through a barn and let us know if she sees anything, any issues that really strike her, or what's good. This is good, I'm good with that, that's not good. So from September of 2024 to now, we've never gotten a notice of any unsafe condition that she saw or any non-compliance that we would have to address. It's been almost 16 months now as of the 24th of this month. So unsafe buildings, our local law requires a notice almost like pretty quickly, because if it's an unsafe condition, we have a right to know about it to correct it. We haven't gotten any, which tells me, and I hope it tells the board, that the barn itself is safe. There's no code compliance that we have to address, except for, like I said, and we're admitting the fire system upgrade has to go in. But we tried, it should have been in, I would have done it in 2023, but we didn't get a permit. So I just wanted the board to know we've really tried hard. The amount, I mean, we're just mentally, emotionally, and financially exhausted with this. We would like to make our great-grandfather's farm productive. We saved it. It was overrun, overweeded. The barn was a mess. The house was a mess when we bought it, but we put a lot of love into it because it was our ancestral home. Our ancestor from Galway, Ireland, 1859, was a farmhand at this farm when he was 19. He built all the stone walls. So it means a lot to us. And you know, this farm brewery, I never would have thought about it. The town asked us to consider doing it. So now that we're doing it, they're not making any accommodations for anything. So we've hit every mark they demanded, but certain things like the construction plans, you just can't, I think we've made 18 or 19 amendments to the construction plans, and nothing's off the table. Nothing has ever come off the table. It's just more and more and more and more. So it's gotten to the point where we needed this hearing because we need the board to tell us, look, you really need to do this, this, and this, or this, and this, and then, you know, or nothing. And so we're just asking.
I'm sorry, for the record, if you're going to testify, you need to provide your legal address for the record, please.
Oh, okay.
If you could.
Barbara Griffin, 1724 Holman City Road, Clayville, New York. Paris, New York.
Did you have something to say? No. This is a difficult hearing for us because it's kind of do or die for us. We put a lot of time into this, and it's just a tap room. If you have 40 people in there, it's like we're always there. It's like we have a 24/7 fire watch because we run it. We don't have employees. We can't afford to hire anybody at $20 an hour in New York State, so we run it. Barbara runs the bar, Rich is the brewer, and he's the runaround guy to do everything that needs to be done. I myself will be running the cafe, which to take the order and get the food out. We've never opened it, so that'll be interesting. And we need some time to get up to speed. Like I said, we have not been allowed in our own barn, so we're way behind in our 50 barrel minimum a year that we're obligated under our farm brewery license to produce. We have to catch that up, and we have to catch that up fairly quickly. We can't do that unless we have a certificate of compliance so that we can access our own barn and do our own thing. So thank you. I'll just keep interrupting because that's what I do.
No.
Okay.
That's what you're here for. You are welcome to provide as much testimony and information as you would like. We're here for you.
Oh, and this is important actually, because when we first started looking at the barn, and first started assessing it, because it was our family farm. So we named Harry's barn after my grandfather, Harry Collins. He grew up there. His father bought it. Our dad and all his siblings, they grew up on the farm. They would come for summers. They'd get crew cuts after school ended in May, and then go to the farm and come back to start school in September with their hair growing back in. That's what my Uncle Jim was telling me. So it's got a lot of family meaning, and it happened that we bought it at the right time where all of our aunts and uncles and our parents they've all now, died and gone to heaven. So, but they had a chance to be back in the farm that they grew up on and they loved. So it was a blessing. But my point is that we would gather in the barn, clean it out, do a lot of stuff for it, and always have an eye toward fire safety. It's a beautiful barn. It's heavy timber. The beams are gorgeous. But it was recommended to us that, look, just to enhance the fire safety of it, why don't you apply intumescent paint? to make it even more safe. And it's like, okay, so Sherwin-Williams produces what's called Fire Guard. We had to do a 2 or 3 application because we wanted it translucent so you could see the wood color and not just paint it white. So it was expensive. I think we spent about $27,000 on that application, but the entire barn has been sprayed. Floors, walls, ceiling beams, all the way up to the 40-foot eave, basement, everything has been sprayed. So it's, not only is it heavy timber with its own fire safety rating, but it's also been sprayed with the intumescent paint. So we really tried our best to do as much as we could to make it as safe as possible. Last year, when the huge snows came and all the barns and the sheds and houses in the area lost their roofs and it was huge collapses, our barn was fine. Our barn was built well. So thank you. That's it for a while.
Is there anybody else that wishes to speak on this matter for the petitioner?
I think Al Zangrilli is on WebEx. He's our engineer.
Good morning. Yes, my name is Albert Zangrilli, address 308 East Noyes Boulevard in Sherrill, New York. And I'm a licensed New York State professional engineer who put together the construction documents. And I have personally reviewed and analyzed the structure in question and have determined without a doubt that it is safe structurally, and for anyone walking in it, it is up to code and meets all the standards.
Meets all the standards for what, sir?
Like snow loading, wind load, snow load,
You're talking about structural standards.
structural standards. That is correct. Yes.
Thank you.
You're welcome.
You say up to code, you mean structurally.
That is correct.
Okay. So we're not talking about handicap accessibility, fire protection systems, mechanical systems, electrical systems. We're talking about structural improvements and structural integrity. Is that correct?
Yes.
Thank you.
Now, Albert also provided the performance review with regards to this project. And as the performance review shows, it does pass all the code requirements as long as the enhanced fire alarm system is installed.
Okay. Do you have anything else you'd like to add, Mr. Zangrilli?
Not at this time. No. Thank you.
Okay. Is there anyone else who wishes to speak on this matter, advocating for the petitioner?
Do I have to say my name before I start speaking? Cynthia Collins, anyway.
Not unless the court stenographer
Okay.
wants to clarify who's doing the speaking.
She knows me by now. I have some letters of support that we wanted to submit to the board just because they came in over the last couple weeks and it was too late to submit it with the petition because first we were supposed to be in Albany on the 21st and then it was moved up to today here. So I would like to submit these into the record just so that the board has it. I know you hopefully will be deliberating. Maybe you could take a look at them.
So if you-
1 or 2 are from our farmer that helps us with the barley and hops. So they're letters just outlining what these people have done to help us and what they've observed, and especially John Burlett, who's the farmer. He has a lot of experience with our barn and our farm. So I would like the board to take a look at them when you have a chance.
So if you'd like to give those to Mr. Fairley and he'll distribute those to the board members.
That's fine.
Mark, when we go off the record, we'll give you an understanding of what we're being given here.
Understand. Thank you.
Okay.
The only other thing that I add that we think is important, is that, when we were open outside in August to October of 2022, and we advised the town we were going to do that, and we were just open on the deck and the lawn, and it was a good way to, get the glitches out, and it was fun, and people loved it. And someone came up to us and was just asking us, why the other barn is open and you're not. So I have foiled the Paris Hill barn and file and was told that there wasn't any information on it. And later we found out that there was, and it was open, and it was a barn very similar to ours. It could have been the same builder. And we were foiling it because we were so confounded with not being able to satisfy Miss Lamont that we thought, well, whatever they did to open, we'll match. If we've missed something or if she forgot to tell us something, we'll just match whatever they did. And then come to find out they didn't do anything. They were just allowed to open as an A2 assembly from a barn, and they're not a farm. They have no farm protections. They just open, which is not your issue, but the type of uneven, unfair enforcement is. All we've ever wanted is a fair assessment of how our barn, compares to what the code requires, especially for an existing building and an 1840s to 1850s barn. Nobody has any records, but my great aunts, who their father was the immigrant, they said that the barn was around in 1850. So, but it's been very difficult for us because we thought we had done everything we needed to do. It's not a big barn, not a big tap room. I mean, we have huge barn doors that are always latched open when people are in there. We could get 1,000 people out in 4 minutes if we have to, and there's not ever going to be 1,000 people in our barn. We have our handicap area ready. We have handicapped access to the deck, which gives access to the barn. We have a lot of egress. I think we have even more egress than is necessary by the code. So we can get everybody out in seconds. And again, we're always there, always 24/7 fire watch when anyone is in the barn. No, when our Harry's barn is open, we're there. We don't allow open flames. I mean, it's a safe. All they do is get beer and cider and walk around, and most of them end up outside. The problem with not having the tap room open for us is when you're weather dependent, it's so hard to manage. It's hard to get musicians. It's hard to, because if everybody's outside, they can't, nobody hangs around. So if it rains, you're closed. So that's why it's so very important for the tap room to be open. And that's why we're here. We need our tap room open. Thank you. I'm done now for a while.
Is there anybody else who wishes to speak on behalf of the applicant? Is the code official present? Would you care to speak on this matter, please?
Yes, we have a representative.
Yeah, I know. But at least I got everything they need to know. They need to know what's.
Hi. Hi, my name is Gina Lamar. Address is LA capital MONTE. Address is 9279 Summit Road, SUMMIT, Cassville, New York, 13318. And we also have Representative Rich Campola from Labella Agency. And you could give your information.
Sure. My name is Richard Campanola. That's CAMPAGNOLA. I'm certified code enforcement official and a third-party representative working with Labella Associates, 4 British American Boulevard, Latham, New York, 12110. Sure. CAMPAGNOLA. On behalf of the town, thank you to the board members for hearing us. This is an application submitted for a change of occupancy, alterations, and repairs to the existing building. The application is based upon the documents that were submitted to the town. As mentioned, there have been multiple submittals over a long period of time, and the town has well documented all the comments on each of those submittals. Because it is a change of occupancy, it is currently a Group U agricultural building, and they are looking to make changes for which they submitted a performance review. Based upon our review of that, the town has issued comments specifically on the Chapter 13 review, which were not otherwise addressed by the applicant, and that was submitted in a letter submitted to the board or submitted to the applicant by the town, itemizing each of the items not in conformance. Basically, Chapter 13 requires under Section 1301.4.3 of the 2020 existing building code, a determination of compliance. And the building official shall determine whether the existing building with the proposed addition, alteration, or change of occupancy complies with provisions of this section in accordance with the evaluation process submitted. As far as the agricultural use, the applicant has submitted a petition under AML 305A to Ag and Markets. One of the documents which the town submitted in its package, I believe it was item 16, was the response to the town supervisor by Ag and Markets, in which the applicant was also copied from Michael J. Latham, the director, which mentioned that they had reviewed the matter with the Department of State, which outlined the requirements of the building code for the change of use from an agricultural building. And as a matter of fact, they basically quoted the entire technical bulletin that was issued concerning the change of use of an agricultural building. Ag and Markets then responded, compliance, basically on October 22nd, 2021, the department reached out to the Department of State Technical Service Support Team and inquired about agricultural buildings that are mixed-use structures and the application of the Uniform Code to such structure, the Energy Code, and the application of portions of the building that would not be accessed by the public, and the calculation of the occupant load. DOS technical staff provided answers to specific department questions, of which, again, the attached response referenced from the technical bulletin. It was noted compliance with MS4 and the New York State Fire and Building Code are New York State regulatory requirements that are administered by local municipalities, the Town of Paris code enforcement official. As such, AML 305A only applies to the administration of local laws, rules, and regulations, and would be applicable in this instance if the locality adopts more stringent requirements than the state requirements. As mentioned, we received construction documents which actually indicate the occupant load would be 226 persons. That would be the basis for the review of the submittal for the application. In addition, as part of the ongoing process, we were requested by the court to make a site visit. That site visit was for the purposes of verifying the type of construction which the applicant is basing their performance review upon. It was, quote, basically, since it's changed over time, we proposed, or the town proposed, that it is a type 5B construction. The applicant has proposed that it is a combination of type 3 and type 4 heavy timber construction. Basically, they're requesting that building consists of two types of construction with no fire separation between those two types. Upon investigation and making that site visit, we verified that the construction type was not as shown or represented on those construction documents. The stone room portion of the building is represented on their submittal construction documents is listed as type 3. The building has masonry walls up to a height of approximately 4 or 5 feet and wood frame type 5B construction above that. So it does not comply with the type 3 construction proposed. They also claim it's type 5 or type 4 heavy timber construction. Upon an investigation at the site, various portions of the structure were measured to verify since the design engineer did not indicate any sizes of the heavy timber construction on their construction documents. We noted in various locations that part of the areas repaired were done in type 5 construction. Other areas did not meet the dimensional requirements of Chapter 23 for heavy timber construction. That was noted in a response as part of the review to the applicant. In addition, it was mentioned that a intumescent paint, which was part of an initial submittal prior to this final submittal, was used to basically provide a fire retardant coating to the structure. Upon review of that, it was requested to provide the special inspections which were never performed during that installation and to have a third party verify that application. A letter was submitted by Flame Control, which was also presented to the court, saying that they could not document it and recommend contacting the original manufacturer. So there was no consistency in the application of this that could be verified to even obtain the required fire ratings. So it's the opinion of the town, based upon the observations of the type of construction, does not meet what's represented on the construction documents. Numerous reviews have been submitted that even though the structural engineer.
I hate to stop.
Sure. No.
Can you push that mic just a little bit further away from you?
Sure, how's that? That work?
That's a little better.
A little more? Sure. The structural engineer's analysis was limited to a letter stating that he inspected it, reviewed it, and it complies with code. No analysis was provided. No structural documentation of sizing of members or anything else was included on the drawings. And based upon observations at the site, which did not match the construction documents, the town basically requested that further review by the structural engineer be provided to confirm what's on the construction documents, which was not provided. In addition, our letter from the town, I don't think you have the date of that letter in the exhibit, documenting the items in the performance review. I do have a copy of that. Dated February 18th, 2025, and if you have the number for that so they can reference. Basically outlined all the items within the performance review that were not in compliance with the code. And the code enforcement official cannot accept less restrictive items than what the code requires. And all of these items were pointed out. In addition to the type of construction, which was the basis of the Chapter 13, again, as per the technical bulletins issued by the state of New York, Department of State, working from a group U to other occupancies does not even apply under the performance compliance method. At no time was the group U proposed to receive a certificate of occupancy for a different type to work from. In any case, based upon the type of construction, the other items reviewed in regards to the performance review had to be based upon what the town recognized as type 5B construction. The number of stories was in question. Based upon observations at the site, they're claiming a mezzanine. However, the mezzanine included an area which the applicant was using for storage, which was not otherwise separated, and that increased the area beyond the limits allowed by the code for classification as a mezzanine, and were designated as such as the third story. In addition, as was mentioned, their fire alarm system was submitted. The application for the fire alarm system was subject to the type of occupancy being used. The submittals that came with that, and those documents are in the applicant's submittal package, were not certified, do not comply with the minimum requirements of NFPA 72, included no calculations. And in addition, they're claiming under the performance review that they're providing a fire command center. Nowhere in the documentation does it show any compliance with Chapter 911 for a fire command center. Based upon all those points and the difficulties, it wouldn't even be possible for the town code enforcement official to reevaluate the performance review because there was no basis for them to start from. And the points just taken out by these miscellaneous items were to reduce the score to non-acceptable in any case. Furthermore, as part of the review done by the code enforcement official, though the structural engineer, as mentioned, identified structural compliance, many items were identified in the review for other aspects, for life safety, for accessibility, which required by the existing building code under section 305. The existing buildings, and it's shown in the photographs that are provided by the applicant, there's a step up to the bathrooms, which makes it non-accessible. There are other accessibility issues as well. There is no information on the mechanical, energy code, or other systems to show compliance with the requirements of the Code of New York State. There is not even a statement as required by the energy code that the design is in compliance with the energy code. So the town over this long period of time has continually documented, and I think the submission that they've provided is well documented since the beginning of this project, of the number of reviews that have been done, the responses that have been issued, noting where areas or portions of the work were not in compliance, necessary for the proposed change of use, alterations, and other repairs to this building.
The only thing I'll add, because there was a couple, Gina Lamont, 9279 Summit Road. I'll only add a couple of things after he went on that, because they stated about Ag and Market, and it did go back to 2021. Actually, Kathleen Tylucky from Ag and Market, they were questioned by them, and she wrote to Gerard Hathaway at the Department of State and what would be needed to change if you could keep an ag building partially ag and partially, change the use. And Gerard wrote back to her on October 25th, that with the technical bulletin, that that the whole building would have to be, if you're changing it, the whole building would have to be changed to assembly or whatever use. You can't leave it half and half. So we understand that. We're not stopping her from having an ag business, but they were explained that if it's a business going in there, it still had to follow building codes, and Gerard sent them that technical bulletin. He even wrote a letter in, what was it, 21, I think it was, 22, stating, he looked at their plans and what was missing and why, and all the defaults in it. The applied coating, we even, it was in 22 for the intermittent paint, where that said that they needed to call flame control, and the specs for flame control, which they didn't attach, it's not to be used on floors or out exterior walls and stuff because it disintegrates. So these are questions, and these is where we asked them, and even the judge asked them to have another inspector come in, and they were going to have Atlantic Testing come in, and it was never done. They were going to get us more. So we never got anything on the intermittent paint that they're using in their Chapter 13 review as a 1-hour fire rating to make it a 5A, and we still have it as a 5B. And she said that 16 months that we haven't told her what's wrong with the building. And as he stated, the only thing we went for in September, because this was in front of the judge that they brought a case against me, that the judge asked us that because Mr. DiTullio and Mr. Zangrilli and all of us agreed it was a type 5 building in Chambers. Then they came back and said, no, it's a type 4. So the judge asked us to go and inspect it. We did, made comments, and it's in your book on section, I think it's in 2024, or right at the end, that it showed the markup plans of what we measured and why it was not a type 4 building. That's a type 5. So every time I get stuff from them, it's a type 4. It's hard, I can't go forward. Because there is not that, for me to document, I'd have to start right from the beginning and do their whole Chapter 13 for them. Because I would have to change the height, the number of stories. So that's where we're on that. And I know this is mute from this, but she put on record about me being unfair, and I'm a scorched earth zoning officer. This barn that she's asking about, in 2017, when it came to my attention that they were operating a business, I also saw this bar. It's called The Barn. So I did question that also, because it's only fair that you do all the proper stuff. We talked to this barn. This barn, it's the title. It's a church. This church was the Congregational Church that was built in like 1920 or whenever it was built. Our lawyer, the town lawyer at the time, the supervisor, myself, met with the representatives of the church and another guy that has a museum in the town. And this building was called the Congressional Hall. It was built as an assembly building back in before 1950. They brought letters and pictures from the museum to show that they had flower shows, dances. So it was always an assembly building. They have 3 acres of land. They never were a barn. So it wasn't a barn that was changed into an assembly building. When a new church bought it, I believe it was 2012, the Three Steeples Church bought it, they just renamed that building the barn from the Congressional Hall. So I just, I know this has nothing to do with this case, but there is a total different building. It's always been an assembly building. There was one, and in her statement in the beginning, she stated all they need is the fire alarm system because all the other work that they did, installing the brewing equipment, the bathrooms, whatever, not one building permit has been issued. I just have to remind you. Bathrooms were installed, brewing equipment, you'll see there's an electrical inspection from 2022 for 5 GFCIs. I did put documents to show you the electric panel and AT. Now there's transformer boxes, there's brewing equipment, there's all different electrical. No permits were issued, no inspections were done, but they keep saying that there's inspection, it passed inspection. There's a furnace being installed, no permit. Any work they did, decks, the decks were never on, those were not permitted. So I just as a reminder, and she admitted that they did all this work and all they need now is the fire alarm system, that not one building permit was issued and I showed you documents of what I needed. Why I could not issue permits until I got the proper paperwork. And I think that's it, what I have to say.
The other thing that we'd add, in our reviews, we have also recommended a course of action that they consider applying for a variance or variances as may be required to comply with the provisions of the code.
Understood. Thank you. Is there anybody else that wishes to speak on this matter?
Well, I'd like to comment if possible from David Ryan. David Ryan, 18 Union Street, Sherburne, New York, 13460.
Turn that one off. Thank you.
I guess there's other information here that has come out and it is clouding the waters from what I can see, because the application that we're working on is October 23rd, and a new application was made with a new set of plans for October 2023 forward. I'm unaware of other stuff prior to that. So our application that, as it was submitted and presented, deals with from October 2023 forward.
Okay. Anything else? Okay. Before the board goes into deliberations, and in light of the complex history of this case, I think it's important to just make a few comments to clarify a couple things. I want to start with the statement by the code enforcement official that it's the town's position that the structure in question was always a place of public assembly. With that being the case, then a group view is not in play. So that changes some things, probably in the applicant's favor. So I just want to get that out there.
I think you're.
Oh, wait, no, not their building. I'm talking about that other barn that they keep,
They cite it as
the one that they cite
So
that is
sorry,
the same
so
as
sorry.
theirs.
Okay, my mistake.
our, our building actually had a chapel in it with the prior owners, and it was, you know, all these barns used to have barn dances in them all the time. My dad came back for World War II and was in barn dances. I mean, so they were all used for assembly purposes, all of them.
Listen, as far as the code is concerned,
Right.
there's a term that we use in code compliance known as the last known legal use.
Right.
So, and there are opinions that have been issued by the Department of State with respect to what the last known legal use is for buildings that existed prior to the promulgation of codes, prior to communities hiring and supporting code enforcement and fire marshal officials. So, you know, at some point when those buildings undergo some kind of work, we have to draw a line in the sand and say, what was it? And how does the code apply going forward? So another thing I'd like to say is with respect to the electrical equipment that we saw in the photographs, that far exceeds that minimal electrical inspection certificate that was submitted in the applicant's package. I just wanted to make a point here that as far as the uniform code is concerned, compliance with all electrical work is actually the responsibility of the code enforcement official by law, who can and often does accept third-party persons and firms to verify the work. But this is not somebody throwing stones. It's actually her and her community's responsibility to issue permits for electrical work and to verify that the electrical work conforms to the code. So I just wanted to make that statement. So with respect to some comments that Rich made, the issue of type 3 construction and type 4 construction, although the construction documents prepared by Mr. Zangrilli are a little cloudy, there is actually a statement underneath that table that acknowledges that they're accepting the fact that the entire building is subject to the least fire resistive construction type, and that is type 5. They acknowledge that there, and they also acknowledge that in their chapter 13. So I just want to clarify that. You also said that they claimed they were putting in a fire command center. That's not entirely accurate. They simply checked a box in the analysis under the chapter 13 alternative path that included a fire command center where in fact one does not exist. As most of us know, that's something that is fairly unique to high-rise buildings. You also said that their documents lacked a statement of compliance with the energy code. There actually is a statement of compliance with both the uniform code and the energy code on the construction documents that were submitted to this board. So I just wanted to clarify that, if I could. So a couple other items of clarification. Ms. Collins, you mentioned several times that you're there 24/7 and that you're conducting a fire watch. That's actually an incorrect statement. A fire watch is actually a legal statement where somebody is on the premises that is qualified, that has independent communication systems, whose sole job is to peruse the facility and watch for fires and other hazards. So you may be there and present and watching a lot of things going on at times when your facility is or was open to the public. But what you were doing is not deemed a fire watch. I also think it's fair to everybody to point out that the eggs and markets law is a great tool to protect, you know, those kinds of facilities that agency is responsible for. But the minute you open it to the public, it has limited value. So, and I'm aware of the letter that was sent to you and to the Director of Eggs and Markets by John Adario, the Director of the Codes Division in Albany, making a statement like that. I'd also like to just state for the record that we're aware that there were events being hosted on the premises prior to any application for a permit. You may or may not have been aware of the requirements at the time, and that's fine. We're not here to throw stones, but there was also advertising being made and social media sites and so forth about this facility being available, although you lacked the required permits. Also like to point out the fact that as a place of public accommodation, this is subject to an operating permit. Nobody has mentioned the fact that an operating permit is a mandatory requirement of the code. And it's a separate application and it's a separate document the town would be required to submit in order for you to operate the A2. Also like to point out that there was work that has been performed in the building without a permit. So I think it's important to get that on the record. Now, that being said, this board will now go into deliberations. We ask everybody in the courtroom to please go out in the hallway. There's a common area. And when the board is done with drafting our decision, someone will come and let you know to come back in the courtroom.
Make one comment for Noel.
You have one more comment, sir?
Yeah,
Please,
just
go
one
ahead.
more comment.
Sure.
The information that we were provided for the fermenting equipment that's there is all their equipment that's there is a standard 110 plug-in. And utilizing the outlets, the existing outlets, or the new outlets that they ended up putting in for that, they had the electrical inspection.
So in fairness to all this documentation, we have photographs of electrical distribution panels and other equipment that are not included in the inspection that was performed. And it's quite obvious to this board that those panels are new, were very recently installed. And it's also highly likely that the equipment that is being plugged in for the brewery operation or cidery operation probably requires a dedicated circuit, not just a standard 110 volt outlet. So, you know, we don't want to get too deep into the weeds here, but I think from the information that was submitted to this board, it appears that the code enforcement official is correct, that there's additional electrical work that has been conducted on the premises that is not included in the electrical inspection certificate. And that's the only point that we're trying to make here.
Right. Mr. Burton, can I just comment on that attached to that NEC certificate was an actual affidavit by Bim Palmer, who did the inspection. And he went through and he actually specified that he inspected the brewery equipment and everything else that was done. So
That's not the document that she is referencing. We don't have a copy of that document.
You don't have it?
We have the certificate that was issued in 2022 that specifically lists 5 120 volt outlets, I believe, and maybe one ground fault circuit interrupter device or something.
Yeah,
I have it here.
but I'm
and
pretty
you
sure,
have it too.
I'll have to check, but I think I
Yeah.
submitted the brewery.
So the time for submitting any
Okay,
additional information for this proceeding is gone.
gotcha.
So, okay, please.
Okay, I just wanted to bring out too, because this chapter 13 is what they're major on. There are, code violations in this building too, which we haven't addressed, but that will, because we were all still working on the type of building to get to that where we were going. But what photos attached, you'll see propane tanks under egress there. You'll see that the plans that Mr. Zangrilli submitted, there is another accessory building. It's a 10 by 12 building that's 7 inches from the building. That's not on the plans, they're in the photos, and they block the aisle of egress, path of egress, once you come out 2 of the exits out of the building too. So there's many other code violations too
Those-
that would need
Those issues
addressing.
are not being addressed.
Oh, sorry.
Those issues are not being addressed by this board today. They are not one of the 4 sections of the code for which the applicant is seeking an appeal.
Mr. Chairman, Dan Farley, Department of State. Are there any other board members that have any comments or questions?
We're going to get there.
Deliberation or-
We're going to get there. We got another hand up.
Yes, Rich Campanella again. Just to address, the town has acknowledged that the least restrictive type of construction may be used. The objection is that it does not meet the initial assumptions for type 4 and type 3. And if anything, it reduces it to a 5B, though the applicant is claiming a 5A.
Fair enough.
Because they're writing in their summary that they're using a 2-hour because of the type 4 in their chapter 13 summary, that they're using type 4 2-hour rating, and a type 5A because of the intermittent paint, they're using a 5 when they're calculating all their documents into that chapter 13, which makes all those numbers different because there's no rating at all in the building.
Mr. Kavanaugh, you have any questions for this applicant?
Yes, thank you. So the first question for Ms. Collins.
speak up,
is
Mark.
that- What's that? I'm sorry. Can you hear me?
No, we can't hear you.
Can
We
you hear me
can
now?
barely hear you. Just turn it up.
Okay. Can you hear me now?
Not really.
How much closer I can get to the microphone. How about now?
Can you hear him?
Talk loud, Mark.
Okay, if you can hear me now, is that better?
Can the stenographer hear him?
It's way too quiet. Seems like it's an issue volume on our end, possibly.
Oh, maybe.
Can you hear me now? 1, 2?
Mark, wait, we're going to check the volume on our end to see if we can fix it over here.
Go ahead and try again, Mark.
Okay, can you hear me now? Can those on the internet hear me all right? Just shake your head. Okay, so they can hear me on the internet.
Greg, can you ask him the question again?
Can you hear me now?
That's better.
Okay. So the first question I have is for Ms. Collins. I believe in your testimony, you were claiming that you were protected by the architectural marketing laws 305A. And I just wanted to verify that you understand New York State Department of State has issued a technical bulletin 2007. And that implies that if it's going to be habitable space, which you are proposing to use, would have to comply with the New York State Uniform Code. And there was a letter on October 27, 2001 from New York State Department of Health providing an opinion to the ag and markets that the entire building must comply with the Uniform Code and Energy Code. So my question is do you understand that or do you argue against that?
No, of course I understand that. What my position would be is that 305A protects us from our farm operation being restricted or regulated if there's no risk to the public health and safety. And the same wording is used in the Uniform Code and the existing code over and over again, public health and safety. And that's my position. That's my understanding. And I just wanted to say that there's a lot of technical bulletins, and in the application, I've submitted the guidelines from the Ag and Markets, which also discusses, we've never objected to meeting code. We just feel that we have, and 305A, it was hard fought. It was a 7-month investigation. And the letter that Mr. Campagnola was referring from Mr. Latham in January of 2022, I believe, he just said if there's applicable code, they have to comply, which we feel we have, and that public health and safety comes first. So that's where we are. And yeah, so I do understand that. I also do understand, though, 305A is important to us because it protects our farm operation. And the farm operation would have been, subject to everything other than the tap room. We've been closed down. That's my position, is that they've ignored our farm operation protections. Forget the tap room, even though that's how we market our crops. And it's a big picture. And that's all. My position is that the town has ignored the big picture. That's it.
Okay, thank you. Thank you for clarifying that.
The documents that we were talking about regarding the electrical is in Exhibit L that was provided.
And there's 4 pages to that. And it has the actual description of the structure that so I hope you have all 4 pages. It does go over that the inspector came back, and what was on the original thing are things that we had to add. And before we had this inspector come in, I called the town and asked, is there an electrical inspector that the town prefers? And I was told by the town clerk, no, just pick one that's NEC approved. So.
Thank you.
Okay.
Okay, the second question I have is for Mr. Campanello. I know there's been, it appears in the documents that we received, there's been several iterations of the compliance path for Chapter 13. And my question is Labella ever determined whether the performance compliance path met the required criteria? Has it ever passed?
No, because of the items that we outlined, which are in the town's specific review letter of the Chapter 13. No, we were not able to determine a passing score.
Okay, thank you. And then is the design architect of record on this call?
So, Mark, yeah, the architect of record was replaced by a structural engineer who is on the call. That's the gentleman that testified before about the structural integrity. You have a question for him?
Sure. So it's Mr. Zangrilli, I believe. And the question I have is that in our packet, this is regarding the flame spread rating or the material used for flame spread rating. In our packet, everything that I read indicated that the material provided and the thickness it was provided to was to maintain or to obtain a flame spread rating, but there was credit taken to make that a fire resistive rating of 1 hour. So what ASTM E119 or UL 263 design was used in order to demonstrate that that product meets a 1 hour listed rating assembly?
I would have to check the file. I don't have that on the top of my head.
Okay, yep. All right, thank you. And that's all, Mr. Chairman.
Thanks, Mark. Any other board members have questions for this applicant?
John Limbeck, and this is for Ms. Collins. You said that the town is hindering your farm operation. Were you still able to plant and harvest the apples and the hops, or is it just the taproom portion of it that's been shut down?
I'm sorry, we're permitted to harvest but not process. So we've got 3,000 pounds of unmalted barley sitting in our upper barn. We're not allowed into our barn to process any of it. So it's probably gone now. We've lost two crop periods because of this. We're not allowed, I mean, our position is we should have always been allowed to use our brewery, even if we just keg and can and bottle and sell it that way, or operate outside where this is what we did in 2022 with no objection from the town. But now we're completely shut down. So yeah, no, we're allowed to harvest, but you can't do anything with it.
I just wanted to
Okay.
understand what the farm operation entailed.
Yeah,
Okay.
thank you.
Thank you.
Craig Jensen with just one question for both the petitioner and maybe for the town. I think you mentioned that the occupant load is around 40 some people based on your design. Is there any disagreement between the applicant and the town with regard to what the occupant load of your establishment would be?
Mr. Zangrilli actually calculated the occupant load at 226 for the entire inside and outside,
Oh, I see, because you had mentioned something about 40
the
some.
tap room.
Oh, the tap.
Yeah, the tap room itself is where the public is. It's kind of small, 40, 50 people max.
Okay, so then how does the occupant load grow to such a, I mean, not outside, outside doesn't really matter to me, but inside.
There's a tap room, there's a room where we would have wedding parties, that holds maybe 50. Off the top of my head, I'm not sure. And then the small stone rooms for private events, they're not primary areas. The tap room is what we need open. And that's about 50, I think.
Okay, I understand better now.
Right.
Okay. Does the town have anything to add there, or if you don't, that's fine. I think I got what I need.
Well, I'll just explain. We haven't agreed on it because the first plans we ever received, it was a 335 occupancy. And we met with their first architect and that's what we agreed on for parking and stuff. And then it changed. They went to, and they did their septic design for 226. But every time we get plans, the occupancy changes. But yes, you'll see photos in there, their winter room, they usually set it up for like 64 people. There's 8 tables of 8. They usually have weddings of 70. Then you have the occupant load of the tap room, which we haven't agreed on an amount yet because we haven't gotten that far after the type. You got the mezzanine that holds people that come out into that same one. So, what do they have on here? So they have the winter room of 54 people, they have the tap room of 53, and then the mezzanine of 24. So you have all these rooms that are all congregating to come out that one accessible area. But that's what the health department's waiting on for the septic was if the occupancy load, once we decide, then it might have to be changed for the design, but we have not come to a conclusion on occupancy yet.
All right, thank you.
Okay. You have something else you want to add, Jen? Okay. The board will now go into deliberations. Thank you very much. We'll let you know when we're ready. Yep. Okay. With respect to the board's decision on petition number 2025-0919, this petition pertains to an appeal for an existing building seeking compliance with Chapter 13 of the 2020 Existing Building Code of New York State for an alteration and change of occupancy from a Group U occupancy to a mixed-use Group A2 Assembly, F2 Factory Low Hazard, and S2 Storage Low Hazard occupancies. The existing building is of type 5B wood frame unprotected construction, 3 stories in height, and contains approximately 6,462 square feet in gross floor area. The building is known as Harry's Barn and is located at 1724 Holman City Road in the town of Paris, County of Oneida, State of New York. The petitioner is appealing the local code enforcement official's determination regarding the applicability of the following sections of the code. 19 NYCRR Part 1227 2020 existing building code of New York State, section 101.3, titled Intent, which states that the intent of this code is to provide flexibility to permit the use of alternative approaches to achieve compliance with minimum requirements to safeguard the public health, safety, and welfare insofar as they are affected by the repair, alteration, change of occupancy, addition, and relocation of existing buildings. The petitioner contends that Petitioner's Chapter 13 Performance Compliance Review Analysis dated February 4th, 2025, and submitted as an alternative method for code compliance of existing buildings is in full compliance with all mandatory provisions of the Uniform Code, the Energy Code, and applicable reference standards, and is therefore requesting that the Board of Review overturn the denial issued by the code enforcement official. 19 NYCRR Part 1227, 2020 Existing Building Code of New York State, Section 102.2, titled Other Laws and Regulations, which states that this code is part of the New York State Uniform Fire Prevention and Building Code. Excuse me 1 minute, please. I am missing a page. Let me have that other version.
See here.
Okay. I'm going to start that last part over again, please. This is one of the code sections that the petitioner is appealing. 19 NYCRR Part 1227, 2020 Existing Building Code of New York State, Section 102.2, titled Other Laws and Regulations, which states that this code is part of the New York State Uniform Fire Prevention and Building Code, promulgated pursuant to Article 18 of the New York State Executive Law. The provisions of this code shall not be deemed to nullify any federal, state, or local law, ordinance, administrative code, rule, or regulation relating to any matter as to which the Uniform Code does not provide. However, subsection 1, pursuant to Section 383, parentheses 1 of the Executive Law, and except as otherwise provided in paragraphs A, B, and C of Section 383, parentheses 1 of the Executive Law, the provisions of the Uniform Code supersede any other provisions of a general, special, or local law, ordinance, administrative code, rule, or regulation inconsistent or in conflict with the Uniform Code. Subsection 2, pursuant to Section 379, parentheses 3 of the Executive Law, no city, town, village, county, or other municipality shall have the power to supersede, void, repeal, or make less restrictive any provision of the Uniform Code. And subsection 3, the ability of any city, town, or village, or the county of Nassau to enact or adopt and to enforce a local law or ordinance imposing higher or more restrictive standards for construction within the jurisdiction of such city, town, village, or county that are applicable generally to such city, town, village, or county in the Uniform Code is subject to the provisions and requirements of Section 379 of the Executive Law. Nothing in this section 102.2 shall be construed as 1, affecting the authority of the State Labor Department to enforce a safety or health standard issued under provisions of Section 27 and 27A of the Labor Law. 2, relieving a person from complying with a stricter standard issued pursuant to the Occupational Safety and Health Act of 1970 as amended. Or 3, superseding, limiting, impairing, or otherwise affecting any provision of the Uniform Code as now in effect and as hereafter amended from time to time. The petitioner contends that the New York State Agriculture and Markets Law 305A should take precedence over the administration and enforcement of the Uniform Code with respect to the granting of approvals and permits in conjunction with the applicant's application for construction permits associated with the work previously performed and proposed to be performed as illustrated in construction documents accompanying the permit application. Petitioner is requesting that the Board of Review compel the code enforcement officer to grant the requested approvals in consideration of the Agriculture and Markets Law 305A. 19 NYCRR Part 1227, 2020 Existing Building Code of New York State, Section 106.2, titled Construction Documents, which states that construction documents shall be in accordance with Sections 106.2.1 through 106.2.9. The petitioner is appealing the determination of the code official that the submitted drawings and analysis do not fully document existing conditions or demonstrate compliance with all applicable code requirements for the proposed change of occupancy, and is requesting that the board overturn the code enforcement official's determination. And last, 19 NYCRR Part 1227, 2020 Existing Building Code of New York State, Section 1301.3, titled Acceptance, which states that for repairs, alterations, additions, and changes of occupancy to existing buildings that are evaluated in accordance with this section, compliance with this section shall be accepted by the building official. The petitioner contends that the code enforcement official has an obligation to accept a Chapter 13 performance review, issue building permits and certificates of occupancy and/or compliance based on the results of the Chapter 13 performance compliance review performed by petitioner's consultant without conducting an independent review. Petitioner is requesting that the Board of Review overturn the denial issued by the code enforcement official. Findings of fact. Number one, this petition pertains to an appeal of the local code enforcement official's determination that the alteration and change of occupancy for the subject building does not comply with the provisions of Chapter 13 of the 2020 Existing Building Code of New York State. Number two, the petitioner contends that sections 101.3, 102.1, and 1301.3 of the existing building code require the code enforcement official to accept the Chapter 13 performance compliance method as submitted and issue the building permit and certificate of occupancy and/or certificate of compliance without mandatory due diligence. Number three, the last known legally permitted use of the existing building was for agricultural purposes, thereby meeting the occupancy classification of a Group U occupancy. Number four, petitioner is proposing a change of occupancy from a Group U occupancy to a farm brewery and event venue containing mixed-use occupancy groups A2 assembly, F2 factory low hazard, and S2 storage low hazard. Number five, for purposes of compliance, the petitioner believes the use and occupancy of the existing building is as a Group S2 low hazard occupancy. The authority having jurisdiction has confirmed that public records do not exist showing that the building underwent a legal change of occupancy from a Group U occupancy to a Group S2 occupancy. Number six, the board finds that the building, as shown in construction documents and photographs submitted by the town, is of type 5B, wood frame unprotected construction. Item number 7 is reserved. Number 8, the board finds that section 101.3 of the existing building code of New York State pertains to alternative methods to achieve compliance for existing buildings affected by repairs, alterations, change of occupancies, additions, and relocations. Chapter 13 of the existing building code does not fall under the intent of this section because it is a code compliance path already permitted by section 301.3.3 of the existing building code. Therefore, relief sought under Part 5 of this petition is moot. Number 9, the board finds that section 102.2 of the existing building code of New York State would not apply to the subject appeal because the Regional Board of Review's powers and duties on appeals are subject to Title 19 NYCRR Part 1205.3 parentheses A parentheses 2, and therefore can only consider matters directly related to the Uniform Code. The Regional Board of Review does not have jurisdiction on matters involving the New York State Agriculture and Markets Law. Number 10, Section 106.2 of the existing Building Code of New York State requires that construction documents, parentheses 1, shall define the scope of the proposed work, parentheses 2, shall be of sufficient clarity to indicate the location, nature, and extent of the proposed work, parentheses 3, shall show in detail that the proposed work will conform to the provisions of the Uniform Code, the Energy Code, and other applicable codes, laws, ordinances, and regulations, parentheses 4, shall include all information required by any provision of this code, including but not limited to the information described in sections 106.2.2 through 106.2.8, and all information required by any other applicable provision of the Uniform Code, and all information required by any applicable provision of the Energy Code, and, parentheses 5, shall include any and all additional information and documentation that may be required by the stricter of the code enforcement program of the authority having jurisdiction, or Part 1203, compliant code enforcement program. Section 106.7 of the existing building code further requires that the construction documents shall provide the information specified in Section 1603 of the Building Code of New York State. The board finds that the construction documents submitted for review do not comply with these requirements. Number 11, Section 101.3 of the existing Building Code of New York State specifically requires the authority having jurisdiction to administer and enforce the Uniform Code and energy codes. Further, Section 102.2.2 of the existing Building Code of New York State finds that no change shall be made in the use or occupancy of any building or structure unless such building or structure is made to comply with the requirements of the Uniform Code and the Energy Code. The board finds that changes were made to the subject building without first obtaining permits required by Section 105.2 of the existing Building Code of New York State, which states in part that no person or entity shall commence, perform, or continue any work that must conform with the Uniform Code and or the Energy Code unless subsection A, such person or entity has applied to the authority having jurisdiction for a building permit, and subsection B, the authority having jurisdiction has issued a building permit authorizing such work. Item 12, Section 1301.4.3 of the existing Building Code of New York State states that the building official shall determine whether the existing building with the proposed addition, alteration, or change of occupancy complies with the provision of this section in accordance with the evaluation process in sections 1301.5 through 1301.9. This provision clarifies that the determination of compliance using this code compliance path lies solely with the code enforcement official. Item 13, the existing Building Code of New York State is an amended version of the International Code Council's published 2018 International Existing Building Code, Section 1301.3 of the existing building code is reproduced directly from the 2018 International Existing Building Code without modification. The International Code Council's commentary for Section 1301.3 of the 2018 International Existing Building Code states in part that when an owner or designer of an existing building decides to apply Chapter 13 and complies with all of the provisions of the chapter, including the applicability requirements in Section 1301.2, the code official must accept for review the proposed work or change of occupancy. However, this section does not require a code enforcement official or the authority having jurisdiction to approve a Chapter 13 performance compliance review or to issue a building permit, certificate of occupancy, or certificate of compliance if their questions or comments regarding code compliance have not been satisfactorily addressed. Item 14. The board there finds that the code enforcement official is not denying the applicant's right to use Chapter 13 performance compliance method permitted under the existing building code of New York State. Item 15, the board finds that the issuance of a certificate of occupancy and/or a certificate of compliance is subject to the determination and approval of the authority having jurisdiction and is therefore outside of the Board of Review's authority granted by 19 NYCRR Part 1205.3, parentheses A, parentheses 2. Item 16, the board finds that the construction documents submitted in support of the application for a building permit contain numerous errors and/or omissions, including several references to construction types other than type 5B, a note indicating the installation of a fire alarm control panel to be installed per drawings. However, no such control panel is shown on the drawings or on the shop drawings submitted under separate cover. Occupant loads shown that appear to be less than the number of persons correctly determined in accordance with Section 1004.5 of the Building Code of New York State. Failure to document or otherwise graphically depict an exterior handicap accessible route in accordance with Section 1104 of the Building Code of New York State. Failure to show handicap accessible parking in all separate parking areas as required by the Americans with Disabilities Act. Exiting from the brewery/cidery area, discharging through a storage room in violation of Section 1016.2, parentheses 5 of the Building Code of New York State. Audio-visual notification devices associated with the smoke and heat detection devices are only shown on the electrical drawings. They are not shown on the shop drawings submitted for this, quote, system. The shop drawings submitted for the fire alarm system do not comply with NFPA 72 as required by Section 907.1.2 of the Fire Code of New York State, which states that shop drawings for fire alarm systems shall be prepared in accordance with NFPA 72 and submitted for review and approval prior to system installation. Structural information submitted does not meet the evaluation criteria submitted in Section 1301.4.1, which states that the owner shall have a structural analysis of the existing building made to determine adequacy of structural systems for the proposed alteration, addition, or change of occupancy. The analysis shall demonstrate that the building, with the work completed, is capable of resisting the loads specified in Chapter 16 of the Building Code of New York State. The applicant submitted statements signed by their consultants certifying the structural integrity of the building and deck without the accompanying structural analysis typically provided to meet the standard of care. A post-installation third-party inspection of the intumescent coating applied to portions of the interior acknowledged that, absent the required testing for mill thickness, they were unable to verify conformance with the code. The narrative, this is item 17 now. The narrative submitted by the applicant in support of the petition for appeal contains inaccurate and/or misleading statements, including the following. A, petitioner claims that the code enforcement official refused to accept a satisfactory performance review, as noted on page 1 of the narrative. However, the board finds that the code enforcement official has accepted every submittal and has taken the time to perform, or cause to be performed, a code compliance review of the materials submitted. Further, the determination of whether or not the construction documents and/or code compliance reports or worksheets comply with the uniform code is at the sole discretion of the code enforcement official. Any reference by the applicant to suggest that the performance reviews was satisfactory is misleading. Subsection B, petitioner claims that the existing structure meets all criteria for a change of occupancy, noted on page 1 of the narrative. However, the board finds that the determination of whether or not construction documents and/or code compliance reports and worksheets comply with the uniform code is at the sole discretion of the code enforcement official. Any reference by the applicant to suggest that the existing structure satisfied any or all criteria for a change of occupancy is misleading. Subsection C, petitioner cites an electrical performance. Oh, I'm going to strike C because I believe that the petitioner has demonstrated that they have had a follow-up inspection of the electrical system. Subsection D, petitioner references a septic system approved by Oneida County Health Department and notes the town's refusal to issue a local permit for the construction and acceptance of same. However, the board notes that the Oneida County approval was based on what now appears to be an incorrect occupant load and was conditioned upon either verification of said occupant load as determined by the town or revised and resubmitted for subsequent approval. Subsection E, petitioner references a decision issued by County Court Judge Murad in August of 2022 with respect to an Article 78 proceeding where the court ruled in favor of petitioners with respect to a matter pertaining to a zoning ordinance suggesting that the entire project was a protected agricultural use. Page 3 of the narrative. However, the board finds that there was a second Article 78 filed against the town code enforcement official challenging her right and obligation to administer and enforce the uniform code. It should be noted that the second Article 78 specific to issuance of building permits and subsequent certificates of occupancy or compliance was dismissed by the court in 2025. Subsection F, petitioner claims several reviews showing code compliance were ignored by the code enforcement official. However, the board finds that the public records show that every design package submitted to the town for review was reviewed by the code enforcement official and or others and found to be non-compliant. Item 18, the Chapter 13 performance compliance analysis contains numerous errors and or omissions, including subsection A, the worksheet and explanation of review that accompanied the performance review worksheet is missing calculations and or explanations to clarify how each of the point values or categories in the summary sheet were determined. Omitted are sections 1301.6.3 pertaining to compartmentation, section 1301.6.5 pertaining to corridor walls, section 1301.6.6 pertaining to vertical openings, section 1301.6.9 pertaining to fire alarm systems, and section 1301.6.18 pertaining to standpipes, and section 1301.6.19 pertaining to incidental use, and finally 1301.6.20 pertaining to smoke compartmentation. Some of the point values noted on the summary sheet 1301.7 are incorrect, resulting in a failure which renders the Chapter 13 code path non-compliant. Examples include the following. Subsection A, section 1301.6.2 titled Building Area. The code requirement states that the maximum value permitted cannot exceed 50% of the mandatory fire safety score in table 1301.8 for the A2 occupancy, which in this case would be a maximum value of 10.5. Petitioner used a value of 10.9 in their summary. Subsection B, section 1301.6.4 titled Tenant and Dwelling Unit Separations. The value used by petitioner was +1, where the actual value equals 0. Subsection C, section 1301.6.8 titled Fire Detection. The value used by petitioner was +6, where the actual value is +5. Subsection D, section 1301.9 Fire Alarm Systems. The value used by petitioner was +5, where the actual value is -5. Section 1301.6.14 Elevator Control. The value used by petitioner was 0, where the actual value is -4. Subsection F, values for the mandatory safety scores applied to the evaluation formula in table 1301.9 should have reflected the values applicable to an A2 occupancy. Petitioner used a fire safety score of 29 where the correct value of 21 should have been used. Petitioner used a means of egress score of 39 where the correct value of 32 should have been used. Petitioner used a general safety score of 39 where the correct value of 32 should have been used. The results of this evaluation, after review of the construction documents and other supporting information accompanying this petition, results in what should have been a failing score for the evaluation formula in table 1301.9. Therefore, the building as currently presented cannot comply with Chapter 13 as a compliance path. New York State Department of State Technical Bulletin TB-2007, Building Code of New York State clarifies how the New York State Uniform Fire Prevention and Building Code applies to agricultural buildings. The Technical Bulletin declares that any structure that contains a habitable space is a place of human habitation and therefore cannot be an agricultural building. These pages got lost here, but conclusions of law. The board finds that the granting of this appeal would substantially adversely affect the Uniform Code's provisions for health, safety, and security, and that insufficient evidence has been provided to warrant reversing the determination of the code enforcement official. In view of the above findings, the board denies the appeal of the petitioner and therefore sustains the determination of the code enforcement official. Wherefore is determined that the application appealing the determination of the code enforcement official from 19 NYCRR Part 1227, Sections 101.3, 102.2, 106.2, and 1301.3 of the 2020 existing building code of New York State be and is hereby denied. This decision is limited to the specific building and application as it contained within the petition and should not be interpreted to give applied approvals of any general plans or specifications presented in support of this application. Do I have a motion to approve?
John Limbeck, I'll make the motion.
Second?
Yeah, Craig Jensen, I'll second that motion.
Mr. Limbeck,
Aye.
Mr. Pappich,
Aye.
Mr. Kavanaugh,
Aye.
Mr. Jensen,
Aye.
and I will vote aye. So the record should reflect that the appeal was denied by a vote of 5-0. And with that, this hearing is closed. Are we off the record? Barbara, are we off the record?